Hearsay. According to the rules of evidence in California, hearsay is evidence of a statement not made by a witness while testifying in court under oath, subject to the jury watching them and subject to cross-examination, and offered to prove the truth of the matter asserted in that statement. Again, hearsay is evidence of a statement not made by a witness while testifying and offered to prove the truth of the matter asserted in the statement. That is, California Evidence Code Section 1200. Hearsay is inadmissible, except as provided by law. The rule against admitting hearsay is an evidentiary guardian of the truth. A statement is either the oral or written verbal expression of a person or nonverbal conduct of a person intended by him as a substitute for oral or written verbal expression. That's Evidence Code Section 225. Hearsay is evidence of a statement. Statements can be recorded. This statement was made out of court. We want statements made to the jury to be in court. This gives it the guarantees of reliability. The witness took an oath, and the jury can observe the witness make the statement, and it is subject to cross-examination. If an out-of-court statement is being offered for the truth of the matter asserted in that statement, that is considered hearsay. The statement, though, can be introduced for another reason, which is considered not hearsay. The statement can be introduced not for the truth, but for a different purpose. For example, to show that the declarant was actually at the scene, not for the truth that is asserted in the statement, but as evidence that they were present. Not that the content in the statement was truthful, just that it is coming in for the limited purpose to establish presence. Hearsay is inadmissible except provided by law, which means that the judges have discretion. They are the guardians, the gatekeepers of evidence. They will weigh the indicia of reliability, the truthfulness, so that it can be relied upon. If it is not a statement, then it is not covered by the hearsay rule. A statement must come from a person according to the Evidence Code Section 225. First step is to consider whether it is hearsay or not hearsay. Is the statement being offered for the truth of the matter asserted or for a different purpose? Now, there are also exceptions to the hearsay rule because the courts want to bring in evidence so we can get to the truth. Any reliability of evidence should be considered. So they have made exceptions to the hearsay rule according to circumstances in which that statement was given because it gives it the indicia of reliability. It can be trusted. Just because a statement was made out of court does not mean the statement is not reliable. The law has exceptions to the hearsay rule. One such exception is statement of a party. A statement of a party is not inadmissible hearsay provided it is offered against the party, not by the party. It must be offered not by the party who made the statement. It must be offered against the party declarant by the opposing party. You cannot offer your own hearsay. You must be the opposing party. Another exception is what we call the prior inconsistent statement at deposition. A prior statement made by a witness that is inconsistent with his testimony can be used to impeach the witness and for the truth of what was said, provided that Evidence Code Section 770 is complied with. Either one, the witness had the opportunity to explain or deny the prior inconsistent statement. There was a opportunity to explain what they mean, or 2, the witness was not excused from further testimony. That means it is subject to recall. That is Evidence Code Section 1235, which means when you call a witness to testify at trial and you're using their prior inconsistent statement that was made at a deposition, you do not relieve them of their duties as a witness during the trial. You let them off the stand subject to recall. The key here again is that you must not excuse the witness. The witness must be subject to recall. You can excuse them subject to recall at the time of trial when they're testifying. When you excuse a witness, it's important to excuse them subject to recall so that you can introduce the hearsay evidence. Very important to note this. Even though the statement is out of court, it is considered to be reliable because under the circumstances of a deposition, the taking of the oath, there is an indicia of reliability. We can offer the evidence not just to impeach the witness, we can also introduce the statement itself, as substantive evidence to be considered by the jury as the truth of the matter asserted in that prior statement. The federal rules are different in this regard. You can only use the prior inconsistent statement at deposition for impeachment, not for the truth of the matter of the statement. That is a distinguishing element between the federal rules of evidence and the California rules of evidence. Inconsistent statement does not have to be complete opposites. Evasiveness of a witness can also give rise to impeachment. You can also just introduce the evidence as impeachment and not for the truth of the matter asserted if you want to avoid the whole argument of complying with the hearsay exception. Another exception is referred to as the business records. According to Evidence Code Section 1271, there is an exception to the rule against the admission of hearsay under the business records exception. A record of an act, condition, or event made in the regular course of a business, as defined in Section 1270, can be used to prove that act, condition, or event in fact occurred, provided 1. The record was made at or near the time of the act, condition, or event. 2. A qualified witness testifies to the identity of the record and how it was prepared. And 3. The source of the information and the method and time of preparation of the record must be trustworthy. That means it was conducted in the regular course of business. It is a standard business protocol, and so it can be trusted. Opinions and conclusions may not be acts, conditions, or events within the meaning of Evidence Code Section 1271. A diagnosis can qualify under Section 1271, like a fracture, but not a psychological diagnosis. And this is according to case law. The federal rules of evidence is different. You can include as evidence opinions and conclusions. There are times when state California rules of evidence and the federal rules of evidence distinguish themselves.